right. Now, it seemed that in Potter and Constantini mentioned in the table of cases, before Forsyth, and this was decided before Forsyth came out. I think we all agree that Forsyth's the leading case in this area. It seemed that Mr. Justice Eberly decided that there had to be some nexus between the alleged sexual conduct and the trial of the offense in question, so that you had to prove that on previous occasions the complainant had engaged in some type of activity which had a nexus or connection or was similar in some way to the events that surround the offense. In other words, some foundation had to be required. Now, my reading of Forsyth is pretty vague as to whether or not what foundation has to be established, and yet when I read Potter and Constantini, it seemed that it was quite clear that you can't just say because a girl had sex with one or two other people on a previous occasion, that therefore you could bring those people in and try to get those events in under a 142 hearing. There had to be some connection, as in the McKenna case, I believe, where a woman was in the habit of going to bars and picking up people. There seemed to be some nexus there. Now, do you think that Mr. Chief Justice Laskin has even touched upon this foundation theme that Mr. Justice Eberly talked about in Potter and Constantini? Bonnie?
Well, I really view the decision in Forsyth as a decision on the procedure to be followed. I don't think it's really of any assistance in deciding how to apply the test. I think the best judicial comment that there's been is the decision in Potter and Constantini, where Mr. Justice Eberly reviews 4 or 5 of the cases, Forsyth in the Supreme Court and Montigny, which is a decision of Mr. Justice DuPont, the O'Brien decision and the McKenna decision. And he concludes from all of those cases, and I think it's been fairly consistently held, that there has to be some nexus of behavior shown to exist, linking them in some way to what is an issue in the trial. And in that passage where he makes that decision, I think he clearly indicates that the mere fact of prior sexual conduct is no longer relevant or sufficiently relevant to meet the test set out in 142 merely by virtue of the fact that you may be able to prove it. You've got to have something more, and I think it really has to be in the nature of a similar fact test.
Can the argument as to whether or not evidence should be called proceed simply on oral discussion? Can you do the whole in-camera hearing just on the basis of argument without calling any evidence?
I think you can. I think now you'd have a hard time convincing defense counsel to do that if the trial judge was disposed to let you call evidence. I know you'd have a hard time convincing Keith Wright to do that.
Peter McWilliams, the collateral question rule was that on matters that weren't an issue in fact in a particular offense before the court, that you couldn't go behind the answer of the witness. So that if the complainant gave a no answer to something that you as a defense counsel wanted yes to, you couldn't rebut that. That was the standard rule of evidence. Is that correct?
That was, yes.
Now, what's the effect of 142 on the collateral issue, collateral questions rule?
Well, this is the surprising interpretation of Section 142, that it, by rendering it an issue that, what is it, in subsection B, that to exclude it would prevent the making of a just determination of an issue of fact in the proceedings, including the credibility of the complainant, has made it a central issue, which is a material or central issue, so that it's no longer collateral. And I really find it difficult to believe that Parliament, or whoever we should say proposed or passed this legislation, ever contemplated that it would be construed as Justice Meredith did in the Morris case, but that's the way it's turned out. And it's ironic. I fear I think it's fair, but I fear that now some new pressure will be exerted on Parliament, or at least the Department of Justice, to change it, to change it back to what it was.
So that if the judge lets this into the trial proper, then you can just go great guns as a defense counsel with this contradictory evidence then.
That's right.
All right. Now, the test in 142 as to the last part that Peter just touched upon requires the judge to be satisfied that the weight of the evidence is such that to exclude it would prevent the making of a just determination of an issue of fact in the proceedings, including the credibility of the complainant. Is there any assistance in Forsyth, Bonnie, as to what this means?
No, I don't think there's, that Forsyth really had to deal with that, and I don't think they made any attempt to deal with it.
Is there any cases that might assist us as to what that means?
Well, I've already referred to Potter and Constantini, which is more of a general assessment of the test and the theory behind the test. Maybe one way I can deal with that question here is to refer to some of the cases specifically. Lonesbury, a question about sexual relationship with 3 named people ruled out. Other persons unknown to the defense ruled out. In Blondheim, specific acts with other persons, the particulars were unknown. The question was ruled out. A third question with respect to the conduct with others, which had given rise to the complainant's reputation as a sexually loose and promiscuous person, was ruled out. McKenna, I guess, is one case where really specific mode of operation being the same. She'd been in that bar with other persons and almost a modus operandi operating. That question was ruled in. Can contrast that with the Murphy case. First of all, behavior supposedly alluring and sexually inviting in a certain tavern, held there was no nexus because there was no suggestion of a later sexual activity in those circumstances. Similarly, behaving in a way to indicate to the male patrons of that establishment her willingness to participate in interactions of a sexual nature. That question was ruled out. Cohabitation with a boyfriend the prior year was ruled out. Question about an effort to obtain a job as an erotic dancer was held not proper under Section 142 by any stretch of the imagination. I don't even know if it's in 142, but also a question concerning the reputation in the community, or phrased that way. And although Mr. Justice Eberly held that general reputation was not within 142 and therefore seems to agree with Laskin, if he's Chief Justice Laskin, if he's going that far, but Mr. Justice Eberly ruled that question out by indicating that what several persons thought of her does not amount to general reputation in the community. So there again, what appeared to be a general reputation question was ruled out, even though Mr. Justice Eberly seemed to feel that was not within the section. Potter and Constantini, questions were ruled out. I could go on and on.
Can the judge in the 142 hearing, he listens to a number of defense witnesses, assuming they're bikers, and the accused calls 4 or 5 bikers, and their evidence is inconsistent one with the other, and with that the judge may have allowed as far as the complainant or anyone else. And he's very suspicious as to the credibility of those witnesses. Does he say at that point, well, it's not for me to question credibility. I think that this evidence is otherwise relevant. I'm going to let the defense introduce it in the trial proper. Or can he rule on it there and say it's just too pat or it's just too contradictory at this point, and it's my function to say that it's not credible and it's out. I'm not going to let it into the trial. Is there any law on that?
Well, I think that when Chief Justice Laskin was dismissing the argument that the complainant was never compellable, he held that on the basis of the requirement that the trial judge assess credibility at the in-camera hearing, he clearly had to hear the evidence. It follows from that he's got to assess the witnesses, so that if you're in a situation where you've got the complainant and what may on the notice appear to be pretty solid evidence and very relevant evidence against her, but all those 5 guys turn out to be bikers and the trial judge doesn't believe a word of it, then I think he has a discretion and an obligation to consider that, and if he doesn't believe the witnesses, I think he has to assess it, and he can rule it out on that basis so that he can make that decision, because he's got to apply the test. He can't just say, well, it's kind of relevant, I'm going to leave it up to the jury, and I think that follows from the logic that was applied in the Forsyth decision.
Are you dealing with the type of questions that the defense might ask on a 142 hearing? We know that prior sexual conduct with the accused, you can ask that outside of 142. General reputation for chastity, it appears from Forsyth and the Queen that you can ask that outside of 142. What about two other areas, the question of virginity and that of venereal disease? Keith Wright, can you assist us as to whether the defense should be allowed to ask those questions?
I tend to think in the society in which we find ourselves today, you'd be asking for an awful lot of criticism to ever get into those areas at all.
Either one?
Yeah.
What if, dealing with venereal disease, the accused said that I would never have had sex with that particular complainant because I knew that she had venereal disease? Do you think that would not be an issue in fact and that would be directly relevant?
Well, I agree that there certainly may be fact situations where these specific issues may arise, but
Generally, you would.
Generally, just taking a broad sweep at those two issues, I'd stay as far away from them as possible.
As a matter of tactics?
Yeah.
I see. All right.
If I might, Al,
Yeah.
back, I have to get a final shot in at that Potter and Costantini and Murphy, those decisions of Justice Eberly on where we go with this test. And I think specifically in Murphy, although I can't point to anything from the Supreme Court of Canada's decision in Forsyth which specifically talks about this, I think there is, just generally reading the decision, a slight movement from the very strict test which was set down in Murphy, this nexus. You got to remember, in the facts in Murphy, there was evidence available. The complainant came up to a witness in the same tavern where she'd met the accused before going to his car, where I gather the alleged rape took place, put her hand on his testicles, and it was held that this shows no nexus to the case at bar since there was no evidence of any later activity with that witness in a car. And to apply a test like that, and I hope I'm being fair to Justice Eberly, but in applying that kind of a test, it just seems to me that you're never going to be able to go anywhere with such an application.
Seems to be a lot of those testicle cases around lately.
I think you just have to take a close look at Forsyth, and I think that the test just cannot possibly be that strict.
All right. Joe? And,
Alan,
sorry.
if you may say, I think someday somebody is going to have to decide what is relevant. You heard Peter McWilliams confess to being a chauvinist and saying that the old law is true. I don't know whether he has to be a chauvinist to do that, because there certainly was a lot of legal opinion that the law was, as I read from that old charge. The other side of it is that, what does the fact that a woman consented to intercourse with A got to do with the issue of whether she consented to the intercourse with the particular accused? I think the fundamental rule of evidence that all the authors go to is the first rule of admissibility is that it be relevant, that is, that it be logically probative, and I stress logically probative of a fact in issue in the case. I am inclined to think that prior sexual activity on the part of the female is a completely irrelevant consideration and therefore basically inadmissible. There are people that go to the completely opposite end of the scale, but I think an awful lot of the problems disappear once you take a relevance, whether the particular prior conduct does in fact bear upon the intercourse being considered in the particular case. I don't know how the cases are going to eventually turn out, but and all of the problems of how do you run one of these in-camera hearings. Well, if defense counsel, I don't think the witnesses have to be called. Defense counsel can say it's our allegation that this woman was a prostitute. She was not paid, and therefore she's yelling rape. Well, obviously the fact on that, and that's a legitimate defense in the case, obviously a relevant part of that is whether or not she was a prostitute. And the matter can be dealt with. If it's the simple fact that she had a boyfriend a couple of years ago with whom she slept on a regular occasion, what's that got to do with the accused? Now, if that's what defense counsel tells the judge he wants to ask the questions for, my inclination would be to say, well, supposing you prove that, and I'll assume for the purpose of this ruling that you have proved through evidence, whether it's of the complainant or somebody else, that she did in fact have an affair with somebody else. So what? What does that prove? And some way or other, I think whether you agree with Mr. Justice Eberly on the facts of an individual case, I really think that ultimately the test is going to come down to one that applies in any contested admissibility issue in a case. Is the particular evidence logically probative of the fact in which it's trying to prove? And until we get some resolution of that, I think we're tilting at windmills.
Forsyth's not the final answer, my lord?
Forsyth, I'm glad to hear that counsel involved in the case of some difficulty deciding what the ratio decidendi of that case is, because when I read it and reread it, I suffered from the same problem, so I did a memorandum to my law clerk to ask her to read the case and tell me what the ratio was. The note that she gave me back is, and I quote, "I'm not sure that there is a ratio in Forsyth."
Thank you. Peter McWilliams, thus far the state of the law. What do you think it's done for the defense or to the defense?
I think it's formally restricted the defense. A lot of cross-examinations that used to be made some years ago, I can recall Henry Bull and Eric Marsden going at it over Marsden's cross-examination of the complete past of the complainant. But I think in recent years, trial judges have tended to protect complainants in any event. I would like to think that to a considerable extent the section wasn't necessary in recent years.
Well, a lot of questions, though, even yet can be put, and were put in the past, were they not, Peter, to a complainant that there might have been very little evidentiary basis for, and then the mere putting of the question can be quite damaging. And to some extent, by Forsyth saying that you can question as to general reputation for chastity or prostitution, you're still allowed to raise the allegation, aren't you?
That's quite right. Oh, I think it's much fairer.
Well, I
think, though, individual decisions, some of them, it's obvious that Keith doesn't agree with them, and I don't agree with them either, but it's a lot fairer than it was before.
Well, I read recently in the newspaper where Lyndon Johnson, before he was going to run for President of the United States, was running some local election in Texas, and apparently it was a much tighter race than he expected. And he said to his campaign manager, "We're going to have to pull some stunt here." And he says, "Go spread around that so-and-so's having sexual relations with his hogs." And the campaign manager says, "Well, we can't prove that." He says, "No, but let the SLB deny it." So I think by analogy, you can still put these questions, and it does an awful lot of damage.
That's right.
Moving on to the second topic, special warnings. Former Section 142 required corroboration of the evidence of the complainant, where for certain offenses, and the judge, if the corroboration wasn't there in his view, had to instruct the jury it was not safe to convict in the absence of such corroboration. Now, corroboration is no longer, perhaps it's important relating to those offenses, but it's not a dead issue by any means. And if you check Section 139 of the Criminal Code, you'll see there are certain offenses for which corroboration is still mandatory. It's under Section 139. Now, there's also the decision in Camp, and perhaps I could ask Bonnie Wein, were you the counsel in Camp?
Not me, David Watt.
You've argued most of these cases. I just wondered if you'd argue that one. Would you tell us what Camp has done? It really was decided after the new 142 came in, wasn't it?
Camp really holds that the removal of the warning of the danger of convicting on the uncorroborated evidence of a complainant in those sections which used to be in Section 142 does not impair the right and, in fact, the duty of a trial judge to instruct the jury to exercise caution in a particular case, not as a matter of law anymore, but as a matter going to the weight of the evidence of the complainant. And if the case is appropriate for that direction, I think the trial judge has a duty to outline what I guess I can call confirmatory evidence that supports her testimony. I don't think it necessarily has to be what in law would have been considered corroboration. Also has to point out problems with her evidence that he sees arising from the facts of the particular case.
So before, under the old 142, complainant testifies, the judge looks around to see if there's any corroboration, such as perhaps emotionally distressed condition, visible marks that might have emanated from a beating, evidence that's independent of the complainant's own testimony. As before, the judge had to use the word corroboration, define that word, itemize the pieces of evidence that were capable in law of affording corroboration. Now you say the judge still has to, even though he doesn't use the word corroboration, still has to, in effect, itemize the evidence that does confirm the complainant's story or that doesn't confirm her story.
In an appropriate case, and I think the way that that's done is set out both in Camp, and there's another decision of the Ontario Court of Appeal in Regina and Newstead, which is in about 40 CCC second.
Darnell and Newstead.
That sets out the same kind of principle and tells you how it was applied in that particular case.
All right. And the third area, and so far we've got, even though 142, the new 142 doesn't require corroboration, we've got those offenses under 139, which I've mentioned. We've got the Camp situation where if you don't use the actual word corroboration, in effect, the judge still has to look for confirmatory evidence. And the third area are those offenses that never were covered by 142. So we're going back to the common law rules. Do you have anything to say on this, Bonnie?
Well, in a decision of the British Columbia Court of Appeal in Cullen, which is reported in 26 CCC second, page 79, they held that there was still a requirement of corroboration under the old common law rules. That decision was given some dispute by the decision of Mr. Justice Dubin in the Camp case, and although he didn't propose to decide the question, he indicated, "I doubt that even with respect to those offenses, the trial judge is presently required to instruct the jury in the language of the former Section 142. I guess from a tactical point of view, what the Crown wants to do in that case where you need either corroboration or confirmatory evidence is look at the expanded definitions of corroboration in the decisions of the Supreme Court of Canada in Workington and Murphy and Butt, and from that you should be able to find something.
All right. Lord, looking at a complainant in a rape case, you're allowed by the Camp decision to ask the jury to exercise caution, particular caution, with a particular complainant, if you so wish. I think I'm right in saying that of Camp, am I not?
I think that's what it says, that there's still a discretion in a court in any criminal case to point out the seriousness of the consequences of acting on the evidence of one witness only. And I think there's a general concern, and as I understand the Camp case, you're still entitled to, and indeed perhaps in some cases it's appropriate to point out to the jury that convicting a person of a criminal offense is a pretty serious matter, and that great care must be exercised, particularly when there's no independent evidence supporting the main Crown witness.
So you really wouldn't distinguish between a sexual case and a non-sexual case, necessarily? Or is there something
Well,
special, as Peter McWilliams seems to think, about sexual cases that requires all these special rules?
Well, when you've been dealing with sexual cases for as long as I have in a particular way, it's hard to teach an old dog new tricks. But so, really, I suppose it should be done on a case-by-case basis, whether you think the particular caution, additional caution other than boilerplate ought to be given.
All right. Now, as far as youthful witnesses, there are some special warnings that are sometimes given. Under Section 586 of the Criminal Code, at trial, it's 586, at trial, there must be corroboration of a witness that's not able to take the oath. Now, the same applies to Section 16 of the Canada Evidence Act, but it seems to apply not only to a trial, but to a preliminary hearing. Now, there was the Katz, K-A-T-Z case that was decided, and I don't know if it's mentioned in the, it's 1980, 13 Criminal Reports 3rd at 277. That's 13 Criminal Reports 3rd at 277, a decision of Mr. Justice Eberly. And he basically decided that even though a child wasn't able to take the oath, that at a preliminary hearing, you could hear her evidence alone, not supported or not corroborated in any way, and still commit. Because by the time trial arrives, she may be sufficiently able to understand the oath. It may have been a lazy Crown attorney that didn't instruct her as to what the oath meant, or may have been other reasons, but it seems that by the Katz decision, you could commit just on her evidence alone, even despite that statutory requirement. Now, there was an article in an annotation in the criminal reports to that by a Windsor University law professor that raised a considerable argument, and that argument was presented again in a case called Stillo, which Bonnie Wein argued, and I think you were supposed to get reasons today. Did you?
I got them yesterday, so I'm a day ahead of you. Katz really didn't decide that it was proper for the trial or for the preliminary hearing judge to commit on the uncorroborated evidence of a child, but it held that the Supreme Court judge on review could consider the fact that she might be sworn at trial. It didn't really directly deal with the issue of whether or not that was an error. Obviously, if he decided to do that, if Katz is followed, then you're just out of luck and you have to go ahead to trial. That decision raised some concern that the Crown would start taking the position that corroboration simply wasn't an issue at the preliminary hearing where there was an unsworn child, and that in fact happened in Regina and Stillo, which was just decided yesterday. The decision of Mr. Justice Corey in that case will alleviate the fears of the defense. He followed the Katz decision and held that there was no jurisdictional error, and therefore the committal for trial was not quashed. But he also went on to deal with the issue of whether it was improper for the trial judge or for the magistrate to consider the fact that a child who cannot be sworn at the preliminary might be sworn at the trial. He held that it was an error not going to jurisdiction. He went as far as to say that it might result in an unfairness. So I guess tactically, if you're a Crown and you've got the unsworn evidence of a child at the preliminary hearing, you should have some evidence capable of being considered as corroborative on the basis of the Stillo decision. In my view, it's no longer open for the Crown to argue on the basis of Katz that although the child is unsworn, corroboration isn't even an issue. In my view, again, the Crown should use the extended definition of corroboration in Workington if faced with that situation.
All right. Now, assuming that a youthful witness is of sufficient intelligence to be sworn, Peter McWilliams, can the judge still give an instruction that they should be cautious with their evidence, and if so, what's the authority?
Yes, Justice Judson said so in Kendall and the Queen, and that was followed in, was it not in the Horsburgh case? But Horsburgh case really was quite a lot more complicated. There, I submit there are really three things combined in the Horsburgh case. First, that they were youthful witnesses with the limitations of their powers of observation and comprehension and recollection and all that. But also, there's a danger when you have a youthful witness testifying as to a sexual case. There's I think it's the Assad and Massaf case or something like that. It's a Privy Council or appeal case in England. It's cited, I think, by Justice Ritchie in the Horsburgh case. So that's the second factor. But there's the third factor, that in that Horsburgh case, that the youthful witnesses were themselves within the extended meaning of the accomplice rule.
That was quite a cause célèbre, that Horsburgh case. I remember at the time it was a minister, wasn't it, down in Chatham or someplace down there, who was charged with alleged sexual offenses, and a number of children that were in a youth group at the church were supposed to be involved.
Yes, it certainly was a tragedy.
So that they were not some of the witnesses in that case, the children accomplices also. Isn't that another thing perhaps that the Crown of Defense should be wary of, is the accomplice warning might have to be given in some of these cases where the victim is at the same time an accomplice?
Where the victim, although the victim, well, I don't know whether they were victims, but the witnesses, the child or youthful witnesses, they themselves were subject to liability. They weren't parties to the offense of contributing to juvenile delinquency, but they were liable to some sort of prosecution in a sort of a vague way as being juvenile delinquents. At least that's what the majority found.
All right. Now, dealing with our third area, we'll have to move along a bit, the complainant. Of course, all this law applies to male complainants as well, although a male can't be raped. Can or should a complainant have her own lawyer? That's a thing that's coming up quite a bit these days. Often you'll see a complainant doesn't have enough confidence in the Crown as being her counsel and wants to retain private counsel. I personally have no objection to that, and I think that most counsel don't really intervene. They may put a little distance inadvertently between you and the complainant in that you're not dealing directly, but I think that if any comfort, as a Crown anyway, can be afforded to the complainant, then that's fine by me. What role they're to play and whether the defense objects or not is another story. The defense hasn't objected in the cases I've been involved in, but in even one case, counsel spoke to an aspect of sentence, the emotional condition of the complainant, and I had no objection. I suppose in some cases I might, depending on the attitude of the defense counsel, but it's never bothered me so far. It's never bothered me that the rape crisis people are there as well, but I know that some defense counsel are bothered by that. Keith, do you have any views on either of those issues?
I think that once the counsel for the complainant starts becoming involved in the actual trial, or for that matter, I guess, sentencing process, there may be legitimate grounds for concern on the part of the accused. I think the counsel for the complainant doesn't operate under the same guidelines as an assistant Crown attorney does, and I would hope that, generally speaking, the assistant Crown attorney is going to be in a totally adequate position to make whatever representations are necessary. And I think, depending, of course, on the facts of the case, I certainly might very well suggest to the Crown attorney in fairly strong terms that any input coming from the counsel for the victim could come to him and leave the final submissions to the court to be tempered by that, as of course any Crown will. On sentence, the Crown is going to listen to the views of the victim, and I think it's best left in that that framework.
Thanks, Keith. Exclusion of the public. At the same time 142 came in, I believe this is when this 442 section was expanded. There was the possible exclusion of the public under 442, but they said with respect to those offenses mentioned in 142, the judge, if he does not exclude the public, must state his reasons, and this really put those sexual offenses in a special category. Now, some judges tried to exclude the public, at least during the complainant's evidence, and the 3 reported cases on this point, Brint, B-R-I-N-T, 1979, that's B-R-I-N-T, 1979, 6 C.R. 3rd, 277, Alberta Court of Appeal, Warawuk, W-A-R-A-W-U-K, again a 1979 decision, 42 CCC, 2nd, 121, Alberta Court of Appeal, and Quisnell, a decision of the Ontario Court of Appeal, that's spelled Q-U-E-S-N-E-L, 1980, 51 CCC, 2nd, 270, were all cases, if I'm not mistaken, where there was an exclusion of the public. And this isn't a 142 exclusion, and they were all sent back for a new trial on that basis. It seems that the appellate courts are very loath to exclude the public, and it's very dangerous as a Crown to ask for that if there's the slightest chance it's going to be sent back. My Lord, what do you think about excluding the public?
Well, I think our courts have to be conducted in public. I think it's dangerous and ill-advised to exclude the public. I think on balance, a great deal more harm is done to the administration of justice as a whole by excluding the public, and will the extra embarrassment be to any individual person involved in the case.
Can you envisage a case where you would exclude the public during the complainant's testimony?
Never have. I can't say it wouldn't occur. I can't think of circumstances that would lead me to exclude the public in any case.
All right.
I can recall a case presided by Justice Chevrier, where he was dealing with a very interesting factual situation, and all the law students were over there at the old City Hall to listen to the evidence, and he cleared the courtroom except for the law students. And then he turned to Rod Cormack there, among others, and said that if any of you are gentlemen, you should be leaving now. And I recall that Rod and I stayed.
Production of the complainant's statement. I've been involved in quite a few of these, and the defense is always trying to get the statement. Sometimes I'll give it, other times I won't. I hope it's not only when there are inconsistencies that I won't, but generally they're pretty successful in getting them. Either I give them, or if the complainant has refreshed her memory before giving evidence, defense always gets them. There's the Monfils case, M-O-N, that's M-O-N-F-I-L-S, Ontario Court of Appeal. 1972, 4 CCCs, 2nd, 163. And if the complainant's refreshed her memory from that statement, the defense is entitled to it. You can also ask for it under Section 10 of the Canada Evidence Act, although there's some authority that it only applies to trial.
Why should there be any problem? Perhaps I didn't do enough prosecuting to understand why this creates any sort of a problem. I would have thought the first statement given by any witness to the investigating officers should be available for defense inspection.
When you've seen some of the preliminaries that I've seen, my Lord, that are 100, 150 pages long, and there's been horrendous cross-examination in my view in the odd case. I'll let defense see the statement most of the time, but I
sure, the in terrorem argument is all very well, but you're dealing with the guilt or innocence of an accused person, and it's very relevant to whether the main Crown witness has made inconsistent statements, whether under oath or otherwise. Well, I don't know how the defense can find that out, get it before the jury unless it's disclosed to them.
Well, it seems to me that they do have a remedy because the police officer takes the stand, and the officer in question who took the statement, I'm not going to hide that from the defense, and they can get out, they can have disclosure of the statement, and they can check it for inconsistency. There is a legal remedy at trial.
Yeah, it's a little tough in the course of a cross-examination to do that. I find it difficult to understand why there should be any problem about this at all.
Perhaps
It's also exceedingly dangerous to go on down that uncharted waters in the middle of a trial in front of the jury, asking the officer what she may have said. Maybe something very damaging she forgot when she was testifying the first time through.
how many crowns in this audience?
Could I add that while the defense naturally try to exclude prior consistent statements of a complainant, the defense, I agree, have the right to cross-examine to show prior inconsistent statements of a complainant, and that came up in DePaggy and the Queen in 1976, 27 CC in Alberta.
If we
Supreme
could,
Court.
dealing with penetration, there is authority that the Crown, if the complainant says, I was raped, that might be enough. But generally speaking, I think it's better as a Crown counsel to actually have the complainant indicate the specifics, and sometimes that's very difficult to extract. I think someone made a suggestion when we were preparing for this that often they just ask the defense, perhaps Bonnie said this, won't you concede if your defense is consent that there was intercourse, and of course it avoids that. And I think that's an excellent suggestion. Perhaps you'd be allowed to lead in that particular area. Included offenses, Bonnie, what do you say about included offenses?
Well, always depends on the facts. I guess the point there is that the Crown has to be prepared to assist the trial judge in deciding what included offenses he wants them to put. There may be situations where it's rape or nothing. I think the trial judge has to make that decision, and the Crown should be prepared to assist him.
All right. If it's, for instance, the defense is, I wasn't even there, it's identity, then the judge would put what to the jury?
I think in that case, unless there's some exceptional fact, would probably have to put the full offense or nothing.
Or if there was defense says, well, everything led up to it, but there was no penetration.
Well, then they might get an indecent assault, depending on what mix of the evidence
What about attempt rape or common assault?
might be.
All right. Forensic evidence. This comes up a lot in rape cases where you see blood groupings, and I find that a lot of defense counsel don't, and perhaps some Crowns aren't familiar with the ABO's blood grouping system, where it can be really vital, because if you establish that your client, as a defense counsel, had a certain blood grouping, and he's the type of person that his blood grouping will come out. If he hasn't given a blood test, and he's what's called a secretor, it will come out in his saliva or other bodily fluids. You don't have to take a blood sample. Non-secretors won't show up in their bodily secretions. The only way you can tell what their blood grouping is if you actually take some blood from them and test it. But often you could disprove that your client was even involved if you can establish that his blood grouping wasn't that what was shown from the semen. And I suggest that you could, it wouldn't hurt if you're going to do a rape case or you're going to do further rape cases that if you're not familiar with that, you really should be. Gynecological evidence is also very important because there's all kinds of aspects of lacerations, bruises, ruptured hymen, presence of semen that gets technical and it's unique to this type of offense. The one area that I think is really important and I'd like to deal with if we could, we're getting near the end, is that of recent complaint. My Lord, you must have, either as defense counsel, heard this instruction millions of times, and the judge since 1970, given it several times. I know the number of criminal cases you've done, a wealth of experience. Can you assist us as to the law in this area?
Well, I think, isn't Boyce in our list of cases?
Yes, it is.
And really, I would just commend anybody to reading Boyce. There are some developments that I think are interesting in the law, but that is the best statement, I think, in recent times of the law with respect to complaint.
Is recent complaint, does it corroborate the story or back up the story of the complainant?
No, it's... I often wonder if a jury would get the nice distinction, but obviously it isn't corroborative because it's not independent. as evidence to show consistency of conduct, of her complaining conduct with the credibility of her story that she had in fact been raped. But we don't, corroboration isn't required anymore, so it's not necessary to go through the rigmarole of telling the jury that it cannot be treated as corroborative.
It says the recent complaint is one that has to be made at the first reasonable opportunity. How recent?
Well, I suppose the law books are full of cases that deal with it. It's not only the recent, it's the first reasonable opportunity. That can depend. It might be a matter of hours or days, depends on the circumstances, or it might be a matter of a very few minutes.
Each case must stand on its own facts then.
Completely.
All right. And what about questions induced, complaints induced by questions? I noticed this Kulak, K-U-L-A-K case that's mentioned in the table of cases, and there, Mr. Justice Martin held that even if the roommate had said, "Have you been raped?" that it wouldn't necessarily be out on those grounds. That it seemed only natural in the circumstances to ask that question. Yet you see some other cases where the trial judge will say, well, that should never have gone in. It was induced by leading questions. It seems to be an area of very subtle distinctions. And Bonnie, could you assist us in any regard?
Well, I think it's an area probably where the Crown has to argue fairly carefully that the type of witness was not really led by the question. If you've got a child witness, you're going to be in a lot more difficulty. But I think the mere asking of the question, were you raped, when you're obviously in a distressed condition, it's not on the authority of Kulak sufficient to rule the recent complaint out.
Okay. Now, what about, my lord, this is a case where, or Peter McWilliams, perhaps, I bounced from here a bit, where the complainant, first of all, speaks to her roommate, will say, and indicates what happens, and then the police come and interview the complainant. Is the jury entitled to hear both complaints?
You're asking me?
Yes, Peter, sorry.
I understand not. There was a Nova Scotia case of not long ago where they held that it's just the first complaint. It's not the second or third one, even though they may be perfectly valid complaints. But it infringes the general rule against evidence of prior consistent statements, as to which a recent complaint is a notable exception.
All right. What about Keith Wright? You think the defense, even though the jury's only entitled to hear that first complaint to the roommate, you as defense counsel, if you thought it would further your cause, could you bring out the fact of the second or third complaints to show perhaps inconsistencies?
Oh, I would hope so. At that point, it's not a question of the Crown leading prior consistent statements from their own witness. At that point, it becomes a cross-examination of a witness, and if there's inconsistencies in statements she's made to other witnesses, then surely you're allowed to bring that out.
Would you allow that, my lord?
Oh, of course. There's no way it could be ruled out. The whole problem is whether the jury is instructed in accordance with Boyce about whether, if the complainant has made a complaint that has been ruled admissible as the first reasonable opportunity complaint, then his evidence tells in her favor, and if she hasn't made one, it's evidence that tells against her. If the defense brings out, and they're not really complaints in the technical sense anymore, they're just prior inconsistent statements, and they're there to be dealt with as any other prior inconsistent statement would be dealt with.
There was one case, Bonnie, where the Crown didn't ask for a voir dire respecting the recent complaint. Was that Boyce? And Would you agree that it seems that a voir dire is mandatory as to, or was it Woodward?
Boyce and Woodworth. It's certainly required in Ontario.
Some of the other cases don't seem to indicate that outside of Ontario.
Outside of Ontario, I think there was earlier authority that, perhaps was ambiguous, but I think it's clear in Ontario that the Crown's got to get a voir dire.
At what point should the Crown ask for the voir dire?
Well, before the evidence is going to arise,
So you start the complainant off? Do you start?
it comes during the complainant's testimony.
Would you lead her up to the events surrounding the complaints and then stop at that point?
Yes.
My lord?
Yes, that's the traditional way to do it, I think.
All right. What about, there are a couple of cases where the complainant tells a person that she was raped and they can't find the recipient of that complaint when trial comes up. Bonnie, can it still go in? Any cases that you know on that?
No, there aren't. You sprung that one on me. I don't see why it couldn't go in.
All right. Is
Can
it
I
Cribs?
rescue her?
Yes,
Cribs
please.
and the Queen, that's the one where the truck driver to whom
Yeah.
the complaint was made couldn't be found. That's the Supreme Court of Canada some years ago.
Thank you, Peter. There was also the Tim case in the British Alberta Court of Appeal, 1980, 52 CCCs, second at 65. That's TIMM, 52 CCC, second at 65, where the complainant couldn't remember the specific words of the complaint, or even that she said she was raped, but the recipient of the complaint could, and it went in there. So this whole area, in my view, is a really complex area, and it almost defies analysis. Do you have any views on that, Warren?
Well, I think that this exception to the hearsay rule is so antiquitous and out of date, and if it ever had any validity, should be done away with. I had occasion not long ago to talk to a group of jurors after a trial, and they asked, one of the women jurors asked why I'd instructed. It was encouraging to know that they had listened to at least long enough to have heard me charge on the complaint. And I said the simple reason I did is the Court of Appeal says I have to. And she said, it's a very stupid law. She said, I would be much more impressed by the evidence of a woman who, after the event, went home, thought about it, considered the hell that she was going to go through if she did complain, and then decided to go ahead and complain, that she'd be more impressed with the credibility of that witness than somebody who shouts and screams as soon as the dirty deed is over. I think Mr. Justice Jessup is making a valiant attempt to at least get some common sense into it with his recent decision in Walters, which is in the list, and he has this. There's a fair bit of debate among the members of the Court of Appeal whether Mr. Justice Jessup is right, but his theory is that there should be no instruction to the jury that an inference can be drawn against a complainant for failing to make a recent complaint without having given her the opportunity of explaining why she didn't. And that seems to me to make a lot of sense.
The situation has arisen, has it not, my lord, where sometimes for perhaps a minor technical reason, the recent complaint went out, perhaps it wasn't in time or something like that, and the defense then cross-examines the complainant, or perhaps go to the jury and say, well, no complaint was made. And not legally admissible, perhaps, but the complainant did complain, and that's the situation that arises. And there seems to be a divided opinion, does there not, as to whether or not the judge can then allow the complainant to testify.
Well, it's a little late when the counsel for the accused is addressing the jury to let the complainant testify again. But, I think there's a real ethical problem that counsel have to face. And in all ethical problems, there's usually a big gray area down the middle. Obviously, counsel couldn't, in Alan's example, I don't think defense counsel could stand up and say no complaint was made, therefore, but would it be wrong because one was in fact made and was ruled out because perhaps it was elicited as a result of questions, or perhaps it wasn't at the first reasonable opportunity, but it was awful damn close to it. Can defense say, well, there has been no evidence put before you of any complaint? And then what does the trial judge do? Does he or she charge in connection with that the absence of the complaint tells against the complainant? Because although there was one made, it wasn't all that recent. I think the whole issue of admissibility of recent complaints should just be done away with. Unfortunately, the law is so of such long standing and by such high authority that only the Supreme Court of Canada or the Parliament can do away with this problem. But I think Mr. Justice Jessup is trying to get it on at least a common sense basis.
Al,
Thank you, Lord. Sorry, Keith.
if I might, on that issue and recognizing the danger of someday being interrupted by his lordship during my address to the jury, I would suggest that the law is that once that ruling has been made by the trial judge that there is not in law any evidence of recent complaint, the judge is required in law to put that direction to the jury, and counsel is entitled during his address to the jury to at least remind the jury that his lordship will be instructing them as to certain cautions which they must take in the absence of that recent complaint, and to argue and perhaps argue quite forcefully that in this case they must be careful to caution themselves.
I think that
I think you're right.
Yeah.
Technically, I don't think there's any doubt the state of the law at the moment that you're right.
I think it was Lordship's opinion was, though, that if I understand him correctly, is that the Crown, even when leading the complainant through an evidence in chief, can go into the fact that no complaint was made and give her a chance to give her failure to make a complaint. I think that's what Mr. Justice Jessup is saying, if I'm not mistaken. Now, the last point, we're almost out of time. This last point that we all want to deal with is the decision in Papa John. And basically, it was a good question. This is the case that followed the English case of Morgan, which holds that an honest belief by an accused that a complainant is consenting to the act of sex is a defense if it's an honest belief, and even though it may be based on erroneous facts. Now, Morgan was a case where I think a man in the Air Force in Britain took a bunch of his buddies home one night and said, my wife is kinky and she likes to engage in sexual acts with others, but she puts up a little act and says she doesn't want to. And consequences were disastrous, and they were all prosecuted. And then our Supreme Court of Canada, there was numerous decisions, I think Plummer and Brown was one and others that followed that. And then Papa John, of course, in our Supreme Court of Canada, followed Morgan and says that in certain situations it can be put. Now, it was a good question in Papa John was whether or not it should have been put in that particular case, because on the one hand, Papa John was saying she was going along with it, and that the complainant's evidence was completely contradictory. He said, I wasn't going along with it, and there the trial judge didn't put the instructions, I remember this case, and the Supreme Court of Canada said that was, in the circumstances, fine. And I think you must read that decision carefully to see whether or not, in the case you might be defending or prosecuting, that should be put if it arises. Bonnie, what do you think about the defense of drunkenness? After Leary and the Queen said that drunkenness and intoxication is not a defense because there's no specific intent required for rape, do you think drunkenness has any application regarding a mistaken belief by an accused?
Well, I guess two comments, one for the defense and one for the Crown. I think that on the basis of Papa John, if you've got a case where you can convince the judge that the mistaken belief defense applies, then logically drunkenness or consumption of alcohol is going to be relevant to the subjective test. So I think to that extent, drunkenness is slipped in the side door or the back door and can be used by the defense in that manner. However, from the Crown point of view, I would point out that in all of the cases where it's been held that the defense might have application, and I think always without success, I might point out, Brass, the Morgan decision, Mazza and Rosado and Plummer and Brown, they've all been situations where there've been multiple accused or at least third-party intervention that caused the so-called mistaken belief on the part of the accused in question, so that although the reasons of Mr. Justice Dixon in Pappajohn may be logical, that you don't need that kind of third-party outside intervention, I would just point out that in all of the cases where the defense has been held to apply, that has been the situation. I think it's a very limited defense.
Do you agree, Lord, that drunkenness slips in here?
Oh, I think so. I think it does.
That's all I want to say. Any closing comments,
Yes,
Keith Wright?
there was a case that is quite different from that situation, which Robert Service could have made a poem about, the Ladue case up in the Yukon Territories, where it's a charge of gross indignity to a deceased or dead body, and the defense was upheld there that the accused was too drunk to realize the girl was dead.
Have to be pretty drunk, I think. That's all we have to say. Thank you very much.